Welcome back everybody to the Law of Tort. We're continuing in this video talking about the concept of causation, examining this idea of a loss of a chance claim. We'll talk about loss of a chance in broad detail in this video before starting to talk about some of the exceptions or some of the alterations of the basic bog standard but-for test, which refers to things like the idea of material contribution and even the Fairchild exception or the Fairchild rule. So, the previous lesson, we spent some time examining what the but-for test actually was when it comes to causation. The but-for test is the traditional examination for the establishment of a causation in fact claim. Essentially, it is asking the question that, assuming in the case of a tortious claim, there is a duty of care and then there's a breach of that duty of care, did the breach cause the damage in question? And essentially, in wording this in relation to the concept of the but-for test, it is asking us the question of, but for the actions of the defendant, but for the breach of the duty of care, would the damage still have occurred? If the answer is yes, if the damage would have occurred regardless of whether or not the defendant had breached the duty of care, then you can claim that it was not the breach of the duty of care which was the cause of the damage. If the damage was not have been caused as a result of the breach of the duty of care, then you can argue that it was the damage that was, that it was the breach of the duty of care that had caused the damage in question, and so we have established causation in fact. This lesson is going to spend some time examining another application of a legal principle, this being the idea of a loss of a chance claim. Now, previously, we spoke about the evidential burden which is placed on the claimant. So essentially what the claimant has to do is prove, on the balance of probabilities, because we're talking about civil claims, that the actions of the defendant were the cause of the damage. Okay, so the burden of proof for the establishment of causation is one that relates to the claimant. The claimant has to prove that it was the actions, the negligence, the breach of a duty of care of the defendant. This was the cause of the damage that the claimant suffered, or at least the claimant's client, assuming that we're talking about a situation in court. But this is what the evidential burden looks like. That's where the evidential standard essentially relates. This is known as the all or nothing approach. Essentially, the claimant has to prove that, but for the actions of the defendant, on the balance of probability, the damage would not have occurred. So it's a particularly high standard. You have to basically essentially invite people into a hypothetical world where the breach of a duty of care had not had happened, and examine what was the factual circumstances had the breach of a duty of care not had happened. If that, in that hypothetical world, in that hypothetical possible world, the claimant still suffered damage, then you would conclude, therefore, that it was not the actions of the defendant that caused the damage. It was some other thing. Or if you look in the hypothetical world where there was not a breach of duty of care, and then it turns out that the claimant was fine, there was no damage, there was no injury at all, then you can conclude quite safely that it was the case that the defendant's actions in breaching their duty of care had led to and caused the damage to the claimant. All of this is an evidential approach and an evidential standard and an evidential burden which is placed on the claimant to prove, okay? Loss of a chance claims are slightly different though, because what loss of a chance claims have sought to do is try and alter and modify the issue of the but-for test by suggesting that claims can be brought on the basis of that the actions of a defendant not necessarily cause the event to take place, but would bring about a situation where the claimant is then deprived of the possibility of avoiding damage. So, essentially what this is doing is, we're not talking here about there being a breach of a duty of care and that breach in and of itself causes some damage. What we're talking about here is that there is a breach of a duty of care, but the breach of a duty of care essentially establishes a situation, brings about a set of circumstances, which then deprives the claimant of their ability to avoid some kind of damage. So it is not the breach of the duty of care directly causing the damage. It is the breach of a duty of care essentially establishing a situation where the claimant, even if they wanted to avoid any kind of damage, could not do so. Okay, that's what a loss of a chance does. It essentially it takes away from the claimant the chance to be able to avoid a damaging situation. They're losing that chance, hence the name. Courts have been very, 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 very strict in their approach to loss of a chance claims. Of course, whenever there is a potentiality for a new claim or a new method of making a claim to be brought to a case and to be brought into the law of tort, courts have always been particularly reticent of allowing them to be to be the case, owing to the policy implications, the potential floodgates implications of allowing a new method of litigation, which could then essentially bring about a whole host of new cases of litigation. So in 1987, we can get an example of how this works in the case of Hudson and Birkshire AHA. This was a case which involved a young boy who had injured his hip as a result of a fall. So he fell over, essentially, and then he had a hip injury. The boy was subsequently, as a result of this injury and the fall, taken to the hospital, where he had been negligently misdiagnosed by the doctor. It was only a few days later when they returned to the hospital, or I believe they maybe stayed in hospital. Essentially, it was only a few days later when the correct diagnosis was made. The mistakenly misdiagnosed original diagnosis was corrected and rectified, and a correct diagnosis was made. Years later, then, the claimant would develop a pain and a disability on the basis of what he claimed to be the failure to properly diagnose the hip injury in the first instance. So this negligent misdiagnosis originally was argued to have been the cause, shall I say, of the disability and the development of a pain. At trial, medical evidence was presented which suggested that had the hospital had made the correct diagnosis originally, there would have been a 25% chance that the boy would have made a full recovery. Okay, so medical evidence at trial actually did support, to an extent, some of the claims that were made by the claimant. That if there had not have been this delay in the correct diagnosis of a few days, and they had been diagnosed correctly originally, then there was a chance, only a 25% chance, but a chance that there would have been a full recovery made by the boy, and this whole disability and this whole pain that was developed would never have happened. So what does this do? Well, this falls below the standard for a but-for test of causation, given the fact that we have to prove on the balance of probabilities, which is more than 50%, that the cause would have not have happened. Sorry, the damage would not have happened if it hadn't have been for the medical misdiagnosis. And so as a result of that, in application of the but-for test, this didn't result in a claim. Okay, there was no claim for the claimant, despite the fact that the hospital did concede that the failure to properly diagnose the claimant originally was the result of negligence. So even though it was conceded by the hospital that there was a negligent misdiagnosis originally, the fact that there was so little of a chance for the boy to make a full recovery meant that the courts were not going to allow this claim to have been made. In 2005, we get the case of Gregg and Scott, and this was also a case which involves medical misdiagnosis and medical negligence at a hospital. The defendant in this case was a doctor, and again had made a misdiagnosis on the basis of a lump which was found under the arm of a claimant. They concluded that the lump was harmless, and as a result, there was nothing to worry about, and so don't get worried about it. Just leave it, and it will go away. However, this was not the case. The lump was not harmless. A few months later, it would later transpire that the lump was a cancer, which at this point had spread to other parts of the body, making it much more difficult for the claimant to make a recovery. Essentially, it was held on the basis of the medical evidence in the case that had the doctor made the correct diagnosis at the time, there would have been a 45% chance of survival. A 45% chance that the claimant would have made a full and speedy recovery. Okay, so this is still less than half. So even if there had have been a correct diagnosis and the doctor had said, look, that lump is serious, we're going to go and have more tests and we're going to get a proper diagnosis of what it is, and we'll treat it accordingly, there would have been a 45% chance of survival. Again, this falls below the 50% balance of probabilities standard for the but-for test. Now, what the claimants wanted to show was that a loss of a chance meant there ought to be liability. Okay, the House of Lords again would reject this perspective. It could not be shown in this case that the chances of survival had been greater than 50%, that the claim itself would have been greater than 50% on balance of probabilities. And so the courts have been always reticent of the fact that if you have a below than 50% chance of the event had not have happened, essentially the negligence had not have caused the damage, then the courts have always been very reluctant to allow liability in those cases.